First to correspondent CB Cotton with the latest. Hi, CB.
Hi, Martha. Yeah, the clock is winding down, and while we wait to see what Trump's next steps are, it appears New York Attorney General Letitia James has laid some of the groundwork for asset seizure should Trump not come up with a bond for nearly $500 million. Earlier this month, James formally registered the staggering judgment against Trump in Westchester County, New York, as you mentioned, which is home to the Trump National Golf Club Westchester and the Trump Organization's Seven Springs estate. Right now, the registration doesn't mean too much, but it is a procedural step that would allow James to secure a lien against properties there in the future. But business law experts tell us James's first steps will likely be.
That clip establishes 3 documented facts that deserve full analytical treatment before we go deeper. First, the date and method of the Westchester filing. March 6, 2024. No cameras, no press conference, no announcement. An attorney general's office employee walking into a county clerk's office and filing a document. I want to hold the procedural quietness of that action against its legal consequence, because the contrast is analytically instructive. The most significant enforcement action taken against Trump's real property assets in the civil fraud case happened without a single press release, without a single statement, without any of the theatrical apparatus that typically surrounds high-profile legal events involving this particular defendant. It happened quietly because quiet is how enforcement actions work in civil law. The drama in the coverage was about the bond, the $454 million number, the countdown clock, the insurance companies saying no. The actual legal work was a clerk receiving a document and stamping it into the county record. That quiet institutional action converted a paper judgment into a documented encumbrance on physical property. No statement required. Second, the precise legal effect of the lien registration. The broadcast characterized it as not meaning too much in the immediate term. A framing that is technically accurate but analytically insufficient because it misses the specific legal consequence the registration created. A judgment line, once registered against real property in New York, attaches immediately and automatically. It does not require a court order to enforce. It does not require James to take any additional affirmative steps. The lien exists on the property's title from the moment of registration. Any title search by a prospective buyer, a lender, a refinancing institution, a title insurance company will reveal it. The property cannot be sold, refinanced, or used as collateral for new financing without the lien being addressed. The lien holder, James on behalf of the state, receives the first call on proceeds from any disposition of the property up to the full amount of the judgment. That is not meaning too much. That is a documented permanent encumbrance that converts a theoretical legal obligation into a physical constraint on the property itself. Third, the timing relative to the appellate arguments. The lien was registered on March 6th. Trump's lawyers were simultaneously in court arguing that posting $454 million was a practical impossibility, that 30 insurance companies had refused to underwrite the bond, and that the asset concentration in illiquid real estate made immediate cash access structurally impossible. The analytical significance of that simultaneity. While Trump's legal team was arguing in court that his assets could not practically be accessed to satisfy the judgment, James was in the county clerk's office making those assets formally inaccessible for any other purpose. The legal argument about impracticability was being made at the same moment the enforcement action was converting the question of practicability from abstract to concrete. That is not coincidence. That is precisely coordinated enforcement strategy, and it deserves the institutional analysis it has not received.
Trump's bank accounts, stocks, and investment holdings, because seizing real estate is always far more challenging.
You would not want to shut down operations by kicking out employees and such. And the property will be most valuable if it continues to operate. I think it would be more like placing a lien against the property so that if he ever tried to sell the property, the state would get its money before he got his money.
Trump's legal team told the court more than 30 insurance companies have refused to accept real estate as collateral to underwrite a bond for the eye-popping total. In response, the Attorney General's office provided a series of suggestions to secure the money, to include a fire sale, but the Trump team has pushed back on all those ideas. Trump has asked the appeals court to accept a smaller bond while he appeals the $454 million judgment, or allow him to not post a bond at all. Martha.
Seven Springs analysis in the source is accurate and precise. I want to build on it analytically in two specific directions that the source establishes but does not fully develop. The first direction, what the valuation gap tells us about the fraud structural design. The second direction, what the fire sales rejection tells us about the relationship between Trump's legal strategy and his brand strategy, and why those two things are not separate considerations, but the same consideration. The Seven Springs valuation paradox, the fraud's self-defeating logic. The source provides the core numbers precisely. Trump valued Seven Springs at between $261 million and $291 million on his financial statements. Independent appraisers valued it at between $56 million and $110 million. Trump purchased it for $7.5 million in 1995. Let me develop the analytical significance of that gap with more precision than the source applies, because the gap is not merely evidence of fraud. It is evidence of a specific type of fraud with a specific self-defeating internal logic. The fraud required that the inflated valuations never be tested by the market. Property values on financial statements submitted to banks and insurers are not market transactions. They are representations, statements about what the property owner claims the property is worth. The lender or insurer reviews the claim, may commission an independent appraisal, which, in the documented record, was sometimes circumvented or ignored in Trump's dealings, and makes a lending or coverage decision based in part on the stated values. For the fraud to produce its documented benefit, $168 million in reduced interest from Deutsche Bank alone, as I documented in episode 4, the inflated valuations had to be accepted as representations without being tested by actual transactions at the claimed prices. The moment a property sold at market price, the market price became the documented real value, and the gap between the market price and the stated value became impossible to obscure. Seven Springs is the clearest illustration of this dynamic. Trump purchased it for $7.5 million in 1995. He never sold it, never developed it, never transacted with it at any price that would have created a market data point about its actual value. For nearly 3 decades, it existed as a documented asset on financial statements at values, $261 million to $291 million, that no market transaction had ever supported, could not be verified through comparable sales of similar properties, and depended entirely on representations that the fraud case established were fabricated using the methodologies I documented in episode 4 through McConney's testimony, adding brand premiums, including the value of unbuilt structures, ignoring legal constraints on development. The lien registration placed on Seven Springs by the Westchester filing created a specific threat to that structure. It forced the question of what Seven Springs was actually worth on a timeline that Trump could not control. If James had moved to a sheriff's sale, Seven Springs would have sold for whatever the market would bear. The market would have answered the question that decades of financial statements had been designed to prevent from being answered. The appellate bond reduction prevented that test. Seven Springs remains unsold. Its value on Trump's financial statements, documented as fraudulent by the trial court and upheld by 5 appellate judges, has never been validated or refuted by an actual market transaction. The fire sale as market truth problem. The source correctly identifies 2 reasons Trump rejected the fire sale option. It would produce market price documentation undermining the fraudulent valuations, and it would require selling properties that were the physical infrastructure of his brand. I want to develop a third analytical dimension that the source does not address: the fire sale as a market truth problem in the context of ongoing financial exposure. Trump's current financial dealings, his business operations, his lending relationships, his insurance coverage, continue to rely in part on representations about the value of his properties. Those representations exist in a legal environment where the fraud finding is documented. The methodology has been described in detail in a public trial record, and independent appraisers have produced documented alternative valuations. If Seven Springs sold at a sheriff's sale for $70 million, that transaction would not merely be an embarrassment. It would be a documented market data point that would be immediately relevant to any subsequent litigation examining property valuations, any lending institution performing due diligence on Trump assets, any insurance company assessing coverage for Trump properties, and any subsequent financial statement that claimed a different value for the same or comparable properties. A fire sale at market prices would have created a documented evidentiary record that constrained the ongoing ability to represent property values inconsistently with market reality. The fire sale's rejection was not merely a financial or brand decision. It was an evidentiary preservation decision, preserving the possibility of continued inconsistency between stated and market values by avoiding the creation of the market data points that would make that inconsistency impossible to sustain. Precise meaning and precise limits. On March 25, 2024, the Appellate Division reduced the bond requirement from $454 million to $175 million and gave Trump 10 additional days to post it. Trump posted it through Don Hankey, a California auto lending billionaire. Within days, the enforcement mechanism paused. Trump characterized this as a big victory. Let me give you the precise analytical assessment of what it actually was, because the big victory framing is neither accurate nor completely wrong. It is imprecise in ways that matter. What the bond reduction actually accomplished. It resolved the immediate enforcement crisis. The lien on Westchester properties remains in place, but no active enforcement proceedings could proceed while Trump pursues the appeal with a posted bond. The properties were not seized. The fire sale did not occur. The immediate threat of asset seizure was suspended. What the bond reduction did not accomplish, it did not reduce the underlying judgment. The $354 million disgorgement order, plus accruing interest, was not affected by the bond reduction. The bond is collateral for the appeal, not a reduction of the debt. If Trump loses the appeal on the penalty amount, the full judgment becomes collectible. It did not change the fraud finding. The Appellate Division's bond reduction order addressed the practical question of whether the bond amount was feasible, not the merits of the underlying case. The fraud finding was not before the court on this motion. It did not stop the interest from accruing. The judgment continues to accrue interest at the applicable statutory rate while the appeal proceeds. The documented amount Trump owes grows every day the appeal continues. And most importantly for the forward-looking analysis, it did not resolve the appellate proceeding on the merits. The Appellate Division subsequently found the $354 million penalty excessive under the Eighth Amendment's prohibition on excessive fines and remanded for recalculation. That recalculation is ongoing as of this recording. The final financial consequence has not yet been determined. The appellate penalty recalculation, the critical ongoing variable, the source's closing correctly identifies the appellate recalculation as ongoing and consequential. I want to give it the full analytical treatment it deserves because it is the most important forward-looking variable in the civil fraud case, and it has received insufficient analytical attention. In August 2025, the Appellate Division found the $354 million disgorgement order excessive under the Eighth Amendment. The court vacated the penalty and remanded to the trial court for recalculation. Two things are precisely true about this outcome, and both need to be stated clearly. What the appellate finding means: the $354 million penalty was found constitutionally excessive. The appellate court determined that the disgorgement order, calculated as the total benefit Trump received from fraudulent financial statements, including reduced interest from Deutsche Bank and other financial benefits, exceeded what the Eighth Amendment permits. This is a documented, significant appellate ruling that reduces the financial consequence of the fraud finding below the original order. What the appellate finding does not mean, it does not mean the fraud did not occur. It does not mean the documented benefits were not real. It does not mean the methodology was legitimate. 5 appellate judges reviewed the full record and unanimously concluded that the fraud occurred exactly as Engoron found. The sole question on which they diverged from Engoron was the amount, specifically, whether the full disgorgement of the documented benefit was constitutionally permissible as a civil penalty. This distinction, unanimous fraud finding, contested penalty amount, is the precise current state of the documented record. The fraud is established. The price is being negotiated between the courts. The recalculation proceeding will establish a new penalty figure. That figure will likely be lower than $354 million. The appellate finding that the original amount was excessive constrains the trial court's recalculation. It will not be zero. The fraud finding is documented, and the courts have confirmed that some financial consequence is warranted. The specific amount that emerges from the recalculation is the outstanding variable. What the recalculation does not change, the fraud finding, is in the permanent record. The independent appraiser valuations are in the permanent record. McConney's testimony describing the methodology is in the permanent record. The Deutsche Bank loan documents showing the documented financial benefit are in the permanent record. The forward-looking finding that the fraud would continue without deterrence is in the permanent record. The financial consequence is being recalculated. The institutional record of what occurred is not subject to recalculation. What the enforcement sequence tells us. Let me state what the complete documented enforcement sequence establishes, because the full picture is more analytically significant than any single element. On March 6, 2024, without announcement, the New York Attorney General registered a judgment lien on Seven Springs and Trump National Golf Club Westchester. Those properties became legally encumbered, unsellable, without satisfying a $500 million debt. 30 insurance companies had reviewed Trump's assets and declined to underwrite a bond at the judgment amount. That documented refusal by 30 separate institutional actors performing independent risk assessment is itself an institutional verdict on the credibility of the stated asset values. The same values the fraud trial had established were fabricated. A court-appointed monitor was watching every significant financial transaction deployed by a court that had found a decade of fabricated financial statements and declined to take compliance on faith. The Attorney General's office put the fire sale option on the table. Trump rejected it. The rejection preserved the gap between stated and market values, preserving both the brand story and the evidentiary structure that ongoing financial representations depended on. The appellate division reduced the bond to $175 million. Trump posted it. The enforcement paused. The properties were not seized. In August 2025, 5 appellate judges unanimously upheld the fraud finding while finding the penalty amount excessive. The recalculation is ongoing. The man who signed the financial statements that the trial established were fabricated. The financial statements that produced $168 million in documented benefits from Deutsche Bank alone is in the White House. The properties whose values those statements inflated remain in his possession. The fraud finding is on the permanent record of the New York court system. The penalty is being recalculated. Series integration, the civil fraud case across 10 episodes. This is episode 10. I want to take a moment to trace how the civil fraud case has developed across the full series, because this episode closes a documentary arc that began in episode 1. In episode 1, I established the foundational numbers. $354 million judgment, $362 million total, 92 pages, Eric Trump liable, the forward-looking fraud risk finding. I framed the civil fraud case as one node in a multi-court accountability network. In episode 4, I built the full forensic analysis of McConney's testimony, property by property, adjustment by adjustment, documenting the aggregate pattern of systematic upward adjustments that Engoron characterized as fraud. That analysis established the evidentiary architecture of the fraud finding. Today's episode addresses the third dimension of the same case: what happened after the finding, in the enforcement phase, when the documented legal conclusion was translated into an attempted financial consequence, and what the gap between the finding's permanence and the penalty's contestability tells us about the structural relationship between legal accountability and actual consequences. That gap is the analytical conclusion of this arc. The legal finding is permanent and documented, upheld unanimously at the appellate level. The financial consequence is contested, recalculated, reduced from $354 million to an amount still being determined. The brand is intact. The properties are encumbered but not seized. The man is in the White House. The scheme that worked for 3 decades, claim your properties are worth more than they are, use those claims to access financial benefits you were not entitled to, produced a fraud finding that will follow Trump through the permanent institutional record. Whether it produces financial consequences proportionate to the documented benefit depends on the recalculation proceeding currently underway. Both things are true simultaneously. The fraud is documented. The consequence is incomplete. That is the precise analytical state of the record. Let me close with a precise statement of what the documented enforcement record establishes, and with the analytical observation that I think is the most important conclusion of this episode. The documented record shows a lien registered quietly on March 6, 2024, no cameras, no announcement, that converted a paper judgment into a physical encumbrance on real property. 30 insurance companies declining to underwrite a bond, each one performing an independent institutional assessment of Trump's asset values and finding them insufficient to back the claimed amount. A court-appointed monitor watching every significant financial transaction, deployed by a court that had spent weeks reviewing fabricated financial statements and declined to extend good faith to the same parties for compliance. The fire sale option offered, rejected, and the rejection preserving both the brand story and the evidentiary gap that ongoing financial representations depended on. A bond reduction from $454 million to $175 million posted through a California auto lender, pausing the enforcement, and an appellate finding in August 2025 that unanimously upheld the fraud while finding the penalty excessive, remanding for recalculation that remains ongoing. Now here is the analytical observation I want you to take from this episode. The American civil justice system is designed to convert legal findings into financial consequences. That conversion is the mechanism through which civil accountability operates, but the conversion is not automatic, immediate, or guaranteed to be proportionate to the documented wrong. It operates through an enforcement sequence, lien, levy, sheriff's sale, that is slower, more complex, and more contestable than the original legal finding. It operates through an appellate process that can reduce the penalty amount while leaving the underlying finding intact. And it operates against defendants whose financial structures, asset concentration in illiquid real estate, complicated ownership arrangements, limited documented liquid holdings, create structural friction between the legal finding and the financial consequence. The fraud finding is permanent. The penalty is recalculated. The properties survive. The man is in the White House. That is not a statement that the legal system failed. It is a statement about what the legal system actually does, as distinct from what people assume it does. The legal system documented the fraud, it entered the finding, it upheld it unanimously on appeal, it initiated the enforcement sequence, and then it encountered the specific structural conditions of this defendant's financial profile. Conditions that are themselves, in part, the product of the same strategy the fraud sustained, and the enforcement sequence produced a result that is real, documented, and consequential, but that falls short of the immediate, complete, proportionate consequence that the dramatic framing of civil accountability tends to imply. This is what accountability looks like in the institutional record. It is not a movie. It is a lien registered without announcement in a county clerk's office. It is 30 insurance companies declining to underwrite a bond. It is an appellate court upholding the fraud and recalculating the price. It is a monitor watching transactions filed periodically with the court. It is real. It is documented. It is incomplete. And it is ongoing. This is Matthew John Turner. The question I want you to sit with is the one the source's closing correctly frames but does not fully analyze. The appellate recalculation is the outstanding financial variable in the civil fraud case. The fraud finding is settled. The penalty is not. The specific number that emerges from the recalculation and the timeline on which it emerges relative to the November 2026 elections and the remainder of the current presidential term is the documented, forward-looking question that the civil fraud arc of this series leaves open. Go read the Engeron judgment. Go read the August 2025 appellate ruling on the penalty, specifically the section on the Eighth Amendment analysis and what standards the trial court must apply on recalculation. Go find the monitor's reports filed with the court. Pull the Westchester County Clerk records. The documents are public. The record is precise. And the gap between the legal finding and the financial consequence it has produced is itself the most honest available documentation of what civil accountability actually is. I will see you in the next one.